Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today we are going to be discussing frequently asked questions about wills. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can find me through social media at Amanda Rocha Law. I get common questions about wills on a daily basis, and I thought that I would create this so that you can decide for yourself whether or not you should Google that question or you can answer the question this way without having to give me a call and then call me when you're ready to create an estate plan. First and foremost, what is a will? I have discussed this at length in the past, but a will is a legal document in which you will put your wishes for your personal and real property to be passed along after you've passed away. So questions are, first of all, can I create a will for my fill in the blank, for my spouse, for my children, for my elderly parents, for my great aunt Stacy, whatever it is? No. You can't create a will for somebody, unfortunately. If you had power of attorney for someone, an acting power of attorney, you may be able to create a trust on their behalf, but a will is a little bit different. So no, a will isn't something that you can create for someone. Second question that I get all the time, can I have a joint will with my spouse, or we'll just take one will, please? You can have a joint trust with your spouse. You cannot have a joint will with anybody. Every person above the age of 18 with mental capacity has to create their own will. You can't share a will with someone else. So, no. Next frequently asked question, why do I need other documents? Isn't a will enough? Well, that question has multiple answers. First of all, a will does not avoid probate, which means that if you only have a will or a will-based plan without more, and you have more than the requisite amount of property, meaning in 2021, if you have over $166,250 worth of property, your estate should pass through probate unless they're joint accounts and that kind of thing. So your estate would go through probate if you had no estate plan or if you had a will-based plan. If you want to avoid probate, you need additional documents. That can be a variety of documents that I don't have to get into here, but one of those documents could be a trust. Second reason why a will is not enough is because a will is only active once you've passed away. So what's going to happen if you were to become incapacitated? You have no other documents to support you in that instance. If you have minor children, that doesn't say anything about a guardian for them if you become incapacitated. It doesn't say anything about what will happen with your finances if you become incapacitated or anything else. Your own health care, nothing. So those are the two main reasons why a will is just not enough. The next frequently asked question that I commonly get is, can I name my kids as my personal representatives? If your children are over the age of 18 and they have mental capacity to do so, sure, you can. Name one person, maybe a backup. But if they're minor children, no, because they can't act in that capacity and you don't know when something's going to happen to you. And if you do that, then a judge will have to determine who your personal representative is going to be. Lastly, why do I even need a will if it doesn't avoid probate? What's the point of having one? Well, if you have, let's say you have less than $166,250 worth of items, you won't have to go through probate, but a will ensure that your items go to where you want them to go. Let's say you have more than that, but they're all most of it is in jointly held property, so that let's say with a spouse. So the community property is going to go to your spouse. Anything else you could make sure passes on to your kids. But most importantly is if you have a trust and a backup as a will, which is known as a pour-over will, if the trust were to fail, at least your will would be in effect to it would still have to go through probate, but the judge would be able to do with, the judge would be able to follow your wishes as to what you wanted to be done originally in your trust, and then because the trust failed, it would be backed up in the will. If you just created a trust with no will and the trust failed, then it's as if you have no estate plan at all. So you definitely need to have a will regardless of what your estate looks like. Whether or not you have $5 to your name or $5 million to your name, a will is necessary even if you need additional documents. If you'd like to create a will, or you have questions about a will, please contact me. You can find me on my website, www.amandarochala.com. You can comment down below if this platform allows you to do that, or you can find me on social media at Amanda Rocha Law. Thank you.